Well, hello. Mike Maloney is my name. And today we're going to have a review of not only what problems estate planning documents address, but we're also going to talk about the solutions they provide. So sit back and relax. And here we go. Well, something bad has happened to you. You've gotten sick in a bad accident. Regardless, you're incapacitated and you can't make financial or medical decisions for yourself. So the question is, what legal documents do you not only have in place, but most importantly, on file with all the firms that you do your financial services business with, relieving those financial firms of liability for allowing your spouse, family member, or trusted friend the ability to access your accounts and make your medical decisions? Now, if you said power of attorney, okay, a power of attorney is a document that will allow somebody else other than you to take over and manage your affairs. And the specific type of power of attorney it's called is a durable power of attorney. And all the word durable means is that it keeps going if you're incapacitated. In other words, this power of attorney doesn't end at your incapacitation. By the way, all powers of attorney end at death. So if you ever hear a family member or friend running around somebody's home or office looking for a deceased person's power of attorney, ask them to stop, because it's a document that just isn't needed any longer. Now, speaking of financial powers of attorney, if that document isn't in place, because with the most respect, it's not good enough to just know what the remedy is. You actually have to have those documents in place to provide a solution to this next issue. Because if you don't have the permission slip for somebody else to manage your affairs, both financially and medically, guess what's going to have to happen? A court process is going to have to occur. And it's part of the probate court process called a guardianship and conservatorship proceeding. What's the purpose of this guardianship and conservatorship proceeding? Well, in its simplistic explanation, it's a court process that's designed to establish that somebody can't manage their affairs, and then to court appoint somebody to manage the finances and make medical decisions for the ward of the state. Now, as I just mentioned, this is a court process. So I think we all understand that when we have a court process, there's going to be an attorney involved. And when there's an attorney involved, I'm pretty confident everybody understands that the fees just aren't a few $100s. They're thousands of dollars. Okay. Now, why is this court process happening? For a very simple reason. The court process is occurring to produce paperwork to put in the hands of your loved one so they now can communicate with your financial institutions and give them the paperwork to relieve them of liability for doing so. Right? Obviously, having documents in place prior to the problem would be a much better solution for, I would say, all of us. The problem with having documents in place, like a financial power of attorney, is that unless you put it on file with your financial institutions while you're competent, there's a very high likelihood that if your family members go to use it, the financial institutions won't accept it, especially if the document is 3 years or older. And why is that? Well, because today, every financial institution has their specific power of attorney policy. And that's just another way of saying every financial institution can decide whether or not they want to accept the power of attorney that your family member is presenting to them. How do you alleviate this issue? By giving them a copy today before there's any incapacity, so that you yourself can hear your financial institution tell you that if you become incapacitated, they are going to accept instructions for those that come after you, whether that's a spouse, children, or another trusted family member or friend. What's the next issue? It's probate. And many of you have heard of probate, but some of you haven't. So what is probate and why does it occur? Well, probate is a legal process for settling a deceased person's estate who is choosing to leave assets to beneficiaries via their last will and testament. Okay. Now, these are assets that the deceased person holds just in their name, not jointly held. Now, here in Michigan, if you die with assets that exceed this threshold, the type of probate process that I'm describing is what's going to happen. So, first purpose of probate is to notify your creditors of your death and make sure they get paid. The next job is to handle any contestments. In other words, deal with anybody that's disagreeing with the distributions that you've left behind or the distribution wishes. Lastly, make sure that both federal and state governments are paid any final taxes. And then the administration process finalizes by transferring the assets from the deceased person to the living. Now, if you've ever had an experience with probate, you know it's not a very quick one. As a matter of fact, most probates take around a year to be completed, and the attorney's fees for probate administration fall somewhere between 4 to 7% of every asset that went through probate. So, in summary, that's $4,000 to $7,000 per $100,000 to do what? For 99% of people, make sure their bills and taxes are paid, and then money's transferred from the deceased to the next generation. Why does probate take so long? Well, I've heard this thought. The reason probate takes so long is when you're going to charge that much money, you got to make it look like it's a very difficult job. By the way, if you own property outside the state of Michigan, not only is there going to be probate in Michigan, but there'll be probate in every state that you own real property in, with more than likely a separate law firm than who's handling your affairs in Michigan. Now, how to avoid probate? Well, we're going to talk about a method today to avoid probate by using a revocable living trust. And let's start with that first word, revocable. It means you can change your mind while you're competent. Living just simply means that you've established your trust today while you're alive. Now, a revocable trust is easy to understand. And in order to do so, I'm going to talk about what you already know. You see all these items on the screen? Real estate deeds, bank signature cards, brokerage accounts, etc. When you fill out the account registration paperwork, or when you sign your deed, those are all forms of contracts. And the contracts that you have in place currently, we all know that you have ownership and control. However, in the contracts you have today, there are no additional instructions that tell any financial institution how you want affairs handled if you're incapacitated and when you're deceased. So what a revocable trust is, very simply, is a contract of your instructions on how you would like your financial affairs handled while you're competent, if incompetent, and when you're gone. Now, when you set up a trust, you're going to have a couple of titles. The first title you're going to have is a truster, and that title is reserved to you. This is your plan, and nobody else is going to be the trustor or creator of your trust. When you set up your trust, there's no doubt that you're going to want to control all of your financial decisions. So you're going to name yourself as a trustee. Now, married couples, just plural the word. Married couples are trustors. They're also trustees of their trust. You are also the primary beneficiary of all your money in the trust that you've established. So with the exception of having different titles in your life, your abilities to operate your financial affairs and benefit from your money is very, very similar to today. Here's the difference. After you establish a trust and you've provided all your instructions for who's going to be your successor. Now, of course, if you're married, that's normally your surviving or competent spouse, followed many times by family members, but it doesn't always have to be. So after you've established who's going to make decisions for you when you can, and who's going to benefit from your assets that you've left behind after you've passed away, once you've established all of that, how you make the trust work, and by work, I mean avoid a guardianship and conservatorship proceeding and avoid probate, is there's going to be a necessity to change title on your assets from the way they're held now to the name of your trust. And I'll give you an example. My wife and I, we have the Maloney Family Trust. Michael and Stephanie Maloney are the trustees. And then we have the date on our trust, that the day we signed it, which is July 29th, 2003. All of our assets, with the exception of our retirement accounts like 401k or IRAs, they're all going to have the title changed to the trust. All real property, all financial accounts and business arrangements will go into the name of the trust. There are no negatives for doing that. It doesn't change anything to do with taxes or your use and control of your money. What's changed is how you're taking title of your assets. It's no longer in your name. It's no longer as joint tenants with rights of survivorship. Your assets are going to be retitled into the name of your trust. And our service helps you do that. Right? What doesn't go into the trust? It's your qualified money. IRA, 401k, 403b, 457 plans, Roth IRAs. You don't change the title on any of those accounts because you as the individual are getting the tax benefits. If you were to change the title to the trust, that would be the same as you taking a distribution, and you would get a 1099 and have to pay taxes. We're not doing that. You keep your IRA 401k money the way it is. Some of you may have your trust as the beneficiary of those accounts because you still have minor children. And what we also do with those accounts is, again, we don't change the ownership, but we're going to put a copy of the financial power of attorney on file with the financial institution so they know your succession wishes if and when you become incapacitated. Right? Now, a little quick summary. You've established your trust, and all that means is you've decided, after you or you and your spouse can't manage your affairs, who are your successors. Next, you've decided, once you or both you and your spouse are deceased, how are your remaining assets and property, how are they going to be distributed, to whom, in what amount, and under what time frame? Okay. All of that is done. You've transferred your assets into your trust. You've gone on living your life. Okay? You're doing the same thing you're doing now, filing tax returns, paying your expenses, investing, using your money. Remember that incapacitation issue I mentioned? Now that happens. Your successor, whether it's your spouse or another family member or friend, with the proof of your incapacitation, which normally comes from a doctor's letter, and the actual document, because remember, all of your financial institutions know about the trust. So your successor has the catalyst that put them in control, or the proof that you can't handle your affairs. They have the document, which is the power, and then of course they can prove who they are. They now have the ability to access all of your accounts and use your money for your benefit if you're still alive but incompetent, paying bills and taxes and just taking care of business. When you pass away, whether it's your surviving spouse or another successor that takes over, there's going to be no need for probate. And if you're married, no need for probate at the first or the death of the surviving spouse. And here's the simple answer why the use of this trust is avoiding the probate situation and the guardianship and conservatorship proceeding. It's this simple. After you establish your trust, and then you retitle all your assets into the name of it, your revocable trust owns your assets. The asset's no longer in your name. Your assets are in the name of your trust that you created, that you're in full control of. And while you're competent, you're the only ones that can change the instructions. However, when you put your asset in your trust, it's no longer in your name. You don't own it. Your trust does. And the reason that you're avoiding guardianship and conservatorship proceedings and probate is because those court processes have to occur because you own assets in your own name. When you change your ownership structure to your revocable trust, you put the settlement of your affairs as part of contract law versus probate administration. Okay. By the way, a lot of folks have questions on fees. Okay. Our clients always know their fee up front. We do not charge our fees based on your ability to pay. We charge based on work involved, and there's two places that there's work. Number one, how complicated are your estate distribution wishes? And what I mean by that is after the surviving spouse, or if you're single, after you're deceased, are your assets distributed equally to your children, which is probably the most common form of distribution for those of us that have kids? Well, as you can imagine, that's a very simple, non-complicated distribution wish. However, everybody isn't equal to the kids. People have unequal distributions. We have second marriage families where sometimes there's a estate distribution to the first spouse who passed away, to their kids from the first marriage, and then a subsequent distribution when the surviving spouse dies. We could have situations where family members aren't responsible with money, so you may want a delayed distribution or distribution delivered over a period of time, let's say annually for the next 10 years, or some now, some in 5, and the balance in 10. Some of you could have children with special needs that are getting governmental benefits. And we can establish your trust with language so that your child can still get the government benefits, but they can also benefit some from you without destroying the benefits that they all have in place. Right? So in summary, sky's the limit on how you want your assets distributed. Right? Where's the other area where work's involved in changes planning fee? How many assets do you have to transfer into your trust? How many pieces of real property, business agreements, accounts, etc.? Once we understand that, we'll be able to give you a price for planning. It's upfront, and as long as your instructions don't change, neither do our fees. Right? One other benefit that you also get working with our firm is we provide you with what's called successor education, so that we can share with those that come after you process and procedure on how to handle your affairs during most likely a very emotional time in their life. Now, be rest assured, we're not talking about your assets or dollar amounts they're going to inherit. We just talk about process and procedure and how they take over and handle your affairs if and when you become incapacitated, and what they do when you die. With that, I'd like to thank you for your time and attention today. And if you'd like to meet on an individual basis to have your questions answered, rest assured you're under no obligation. And if we understand your situation during this consultation, we can give you all the details, including costs for your planning. With that, this is Mike Maloney saying thank you for your time, and you have a fantastic day.